Real estate contracts often include a financing contingency, also called a loan contingency or mortgage contingency, requiring the buyer to secure financing as a precondition to the sale. An appellate court in Maryland considered whether the buyer's mortgage application submitted before the contract was signed constituted compliance with the financing contingency's time limitation in Proctor versus Holden. Michael and Deborah Holden were in the market for a new house closer to their families in Baltimore and Annapolis, so they applied for a mortgage with Magnet Mortgage. Shortly after that, John and Deborah Proctor agreed to sell their house to the Holdens for $210,000. The contract included a financing contingency, which required the Holdens to apply for financing within 5 days of signing the contract. The signing happened on July 26th, and the Holdens paid the Proctors the $20,000 deposit called for in the contract. Unfortunately, on August 1st, Magnet Mortgage notified the Holdens that their mortgage application had been rejected because of their high debt-to-income ratio. On August 9th, the Holdens applied for a mortgage with a second bank, but that application was similarly rejected within a few days. At this point, the Proctors offered owner financing to the Holdens, but the Holdens declined this offer. Instead, they requested a refund of their $20,000 deposit based on their inability to secure financing. When the Proctors refused to refund the deposit, the Holdens filed suit in Maryland State Court. The jury found for the Holdens, and the Proctors appealed to the Maryland Court of Special Appeals. The Proctors argued that they were entitled to keep the deposit because the Holdens breached the contract by not complying with the 5-day time limitation and by declining their offer of owner financing.